I'm Vilma Vodanovic. I'm joined by Alice Richardson, Tom Tyson, James McHugh and Morgan Brien, and we are barristers at Trinity Chambers in Newcastle and Leeds, and we specialise in housing law and property litigation. Between the five of us, we will be bringing you a series of webinars looking at the appeals process in the first tier tribunal property chamber, and specifically looking at the measures adopted by local authorities against private landlords in the residential rented sector. Now, the jurisdiction of the first tier tribunal seems to be less familiar to many than the remainder of the civil jurisdiction in the form of the county court or even the criminal jurisdictions to the magistrates court. But the tribunal procedure does differ, as does the jurisdiction. So that is what we're going to be visiting over the course of the webinars. The first webinar that Tom and I will deliver will be all about the tribunal process, which Tom is going to tell us more about.
Yep, in the first webinar, Vilma and I are going to have a very practical overview of the appeals process within the first tier tribunal, from lodging a form, dealing with any tribunal directions, and looking at the procedure in the run-up to the hearing, how to prepare for it, and then the hearing itself, telling you a little bit more about the tribunal's jurisdiction and how best to utilise it.
Great, thank you, Tom. So our aim with all of these webinars will be to provide an overview for all of those who deal with this process. So the appellants themselves, the landlords who are appearing in these appeals, whether they're represented or not, to respondents who are the local authorities and those who are involved on their behalf, so their legal advisors, their housing or environmental health officers who appear as witnesses, or other witnesses who are appearing. So we're going to try and make it practical for all of those involved in that certainly first webinar that Tom and I will do, and then when we'll look at more substantive matters about measures adopted by local authorities, and again looking at it from the perspective of all of those persons I've just mentioned. The second webinar that we will be doing will be delivered by Alice Richardson and Morgan Brien, which will be on licensing of houses in multiple occupation, and Morgan is going to tell us a little bit more about that.
Thanks, Vilma. Yes, good afternoon to everyone. I, along with Alice, will be delivering the next webinar. The focus of that will be on licensing issues in relation to HMOs. We will mainly be discussing the different types of offences that are being committed under the Act, as well as having a quick look at the various statutory defences available. We'll go through the types of conditions that are attached to these licences, and we'll end with a very brief overview of the management of HMOs regulations of 2006.
Okay, thank you. And the third webinar in our series is going to be about improvement notices and prohibition orders, which again Morgan will be dealing with together with James McHugh, and we'll get James to tell us a little bit about that.
Yeah, thanks, Vilma. What we're going to be discussing in that webinar are the technical requirements relating to improvement notices issued by local authorities, the appeals process for dealing with improvement notices, and the various details that are set out in Schedules 1, 2 and 3 of the Housing Act 2004.
Thank you, James. And the last webinar in that series is going to be about civil penalty notices, which is an option available to local authorities instead of prosecuting as an enforcement measure against landlords. And Alice and I will cover that topic. So Alice can tell us a little bit more about that.
Thanks, Vilma. Yeah, so we're going to be talking about what civil penalty notices are, what the offences that civil penalty notices can be served for are, the factors that local authorities take into consideration when deciding whether to prosecute or issue a civil penalty notice, how local authorities decide the amount of that penalty, which can be up to a maximum of £30,000, and how the process that local authorities have to take before serving the notice, and the process that landlords can take or letting agents can take in appealing the notice.
What we're going to do now is have a brief discussion around the current state of appeals in the first tier tribunal and what's happening. Obviously, at the moment, there are no face-to-face hearings. Site inspections have been cancelled, and there are currently being users are currently being given the option for paper hearings or telephone hearings. In light of that, there can be a bit more focus required prior to the hearing to get the case ready to go. So what issues have you guys been finding that you're being asked to do for your clients to help things get ready for the hearings more effectively? Tom, have you got anything that you'd like to add in relation to that?
Yeah, I think at the moment it's not been issues coming from clients so much as issues coming from the courts and tribunals, who are getting in touch with the legal representatives and asking us whether these things can be dealt with on paper, whether they can be dealt with over the telephone or on some other remote platform. So it is becoming increasingly important to get the paperwork in order and to find out the cases that can be dealt with on paper, the ones that are dealt with by way of legal submission on agreed evidence or facts that aren't materially in dispute. If that happens, then it's just a question of a short, succinct and punchy skeleton argument, and this is business that can still carry on in the FTT. But if it is a matter that requires a lot of contested evidence, I can't see it being dealt with very easily over the telephone. I don't know if anybody else has had any experience of a contested telephone hearing in the FTT. I know that employment tribunals are trying to do that, or at least trying to use Skype for business. But I haven't heard the same in the property chamber.
I personally haven't had any hearings conducted by telephone which have been contested in the FTT in the last few weeks, but I can certainly imagine that for a number of ongoing cases which have been adjourned, that option isn't going to be particularly attractive where there's a lot of contested evidence. I know that a lot of the appellants themselves are wanting to have oral hearings, telephone hearings, as opposed to paper hearings. And you can see why they might want that, because it's easier to explain their case, at least if they've got the tribunal on the phone. But where there is tricky evidence to be given, cross-examination and so on, I can see there might be some difficulties with that proceeding to its fullest. So one of the things that I certainly have been helping both local authorities and appellants with is narrowing the issues, whether it's for telephone hearings in the future that might be listed if they ask for one, but it's to make it easier for both sides to simply to narrow the issues and to get the tribunal to focus on what they can during the hearing.
Does anybody have any views on whether or not local authorities might find it more difficult or not to take enforcement action in the current climate?
I can currently see that happening in terms of enforcement, simply because in current circumstances, the inspection that results as following a complaint by a tenant is going to be very difficult to carry out within the COVID-19 regulations. To get local authority officers out there and into somebody's premises during lockdown, I think is going to be very difficult indeed. I don't know how local authorities are or could respond to that in the interim period, but I think that's going to put quite a significant spanner in the works of taking enforcement action.
The guidance that's been issued by the government, non-statutory guidance, on which we've written an article which is on our website, and there's a link on that, and a link to the guidance can be found on that. Effectively, the recommendation by the government is that local authorities should take enforcement action only where it's necessary to do so, and what they're inviting local authorities to do is to update their policies on enforcement, but also update their policies on when they go into properties, how they go in, and whether their staff are going to be safe. But also there are going to be other considerations as to all those who want to attend those inspections, whether they are going to be safe, whether tenants are going to be safe. There are a number of practical considerations, as you say, Tom, in terms of how these are going to continue. But the enforcement action is still going on, especially where it's particularly serious. So local authorities are going to continue taking some form of action. And there are going to be notices issued and so on. The process is still going to go on. So in terms of appealing, the deadlines are still there in terms of lodging appeals, and those haven't changed and they have to be complied with. So there are steps that landlords can still take before the appeal process where they need to consider whether they need to respond or take any action. So for example, the notice of intent before the issue of the final civil penalty notice. There's an invitation for representations to be made, and that has to be done within a specific time period. So that is still going to continue, and landlords need to be aware that they still have to respond to this.
Over the next few weeks, we'll be delivering these webinars in hope of assisting all those involved in this process by providing some practical advice and guidance on the subjects, as well as dealing with any issues that arise and how to deal with these issues that may come up on a day-to-day basis. We'll be advertising these webinars on our website and over social media, so please watch out for them. Don't hesitate to get in touch if you have any queries, or equally if you have any recommendations that you would like us to cover in the next couple of weeks. Thank you for listening, and we hope to see you soon.
I keep looking down there because I haven't had my lunch yet, and I've got a fish finger sandwich just off camera.
Would you like to eat that?
I'm going to resist the temptation.
Yeah,
that works.
So who presses record? What happens?
It's recording now.
Oh, it is recording now. Good. Excellent. So what do I do? Just say start and then I start?
Yeah.
Yeah, this is going to go in the bloopers.
Definitely.
What? I don't know what to do.
We want to know how quickly Tom can eat a fish finger sandwich.
Anyway, it's still there. Sorry. Can I start again? I've got a spaniel looking at my fish finger sandwich now. Murphy, go on. Go see Fred.